Good morning, everybody. So we are starting the section-wise analysis for our Saturday morning sessions from today. So today we have Annapurna Kabra Madam as our learned speaker. So I am inviting Arpit ji to introduce the speaker.
Thank you, Unikrishan ji. And today, as said, today's speaker is CA Annapurna Kabra ma'am. She is a fellow member of the Institute of Chartered Accountants of India. She has contributed articles on VAT and GST and regular contributor of articles to various professional journals, including Bangalore branch of ICAI, Karnataka State Chartered Accountants Association, and SIRC Journal and IDTC Committee of ICAI. She has also assisted in drafting background material of GST for ICAI and technical guide to GST audit of ICAI. She has co-authored the book on refund under GST to KSCAA, and she has contributed e-lecture on various topics in VAT and GST to IDTC Committee of ICAI. She is a faculty to a GST certification course conducted by ICAI, and she is a member of Bangalore Study Group of ICAI. She is a committee member for development of study module for Karnataka State GST officers and regular faculty to Fiscal Policy Institute. Apart from that, she has addressed a gathering of chartered accountants, tax practitioners, dealers, students, and departmental officers on indirect taxation matters, including GST, in various forums. She is practicing in Bangalore and a proprietor of Annapurna and Associates. I welcome Annapurna Kabra ma'am for today's session, and back to Unikrishan ji.
Ma'am, we welcome you to start the session.
Yes, sir. Good morning, everybody. Thank you for your kind words, our mentor of this group today. And thank you, Uni, for giving us the opportunity, and Arupji and other members to speak on the Section 3 and Section 4 of the GST Act. Before beginning into the session, I request Arpit sir or any other faculty, if there's any other views on that slide, you can just stop me in that, or you can just share it at the end of the session. So with your permission, I would like to start the session on the one of the most important section, which I felt when I read this section. Actually, this section we have not read. This is the first time I'm presenting on this section, especially Section 3 and Section 4 of this GST Act. So with this, let me start on the topic. So very basic first slide, which we look is Section 2, which I have tried to connect some of the definitions, which are very relevant to understand the Section 3 and Section 4 of the GST Act. So before looking into that, I've just tried to see what are the important definitions. So one is Section 2, subsection 16, which I'll go through a little faster so that as we all are well versed with this. But just for the reference, I'm trying to bring out what is the board which is defined, which is nothing but CBIC, which was earlier CBC, which is constituted under the Central Board of Revenue Act 1963, under the Department of Revenue with the Ministry of Finance. Then we have 2 subsection 24, which has specifically defined who is the commissioner. So commissioner means the commissioner of central tax and includes the commissioner of central tax appointed under 3 and commissioner of IGST, who is defined under IGST Act 2017. Then we also have 2 subsection 25, which define who is the commissioner in the board. So specifically, they have brought commissioner in the board means the commissioner, which is referred in Section 168, which we are going to deal in detail in the later slides. Then the 2 subsection 53 also define government. That means central government for CGST Act and state government for the SGST Act. And Section 2 subsection 80 defines notification, which is a notification which is published in the official gazette. And the expression notify and notified shall be construed accordingly. And there is a very important definition of proper officer in the GST Act, that is 2 subsection 91, which states that in relation to any function to be performed under this Act, means the commissioner or the officer of the central tax who is assigned that function by the commissioner in the board. So I think these are the definitions which are relevant to understand Section 3 and Section 4 of the GST Act, and some aspect of Section 5 is also discussed to understand better Section 3 and Section 4 of the GST Act. Now, the most important section is, that is the first section of the Chapter 2, that is Section 3, officers under this Act. So the section begins with the government shall, by notification appoints the following class of officers for the GST. So they have specified, they have classified the following officers, which are like Principal Chief Commissioners, Principal Director General of CT, Chief Commissioner of Central Tax or Director General, principal commissioner or principal additional director of central tax, commissioner or additional director, additional commissioner, additional director, joint commissioner, joint director, deputy commissioner, deputy directors, assistant commissioner or assistant director, or any other class of officers as it may deem fit, provided that the officers appointed under the Central Excise Act shall be deemed to be the officers appointed under the provision of this act. I'm just trying to read the section before understanding the implication of section 3. So this is a section which is provided in CGST Act. Now the section has begun with this government shall by notification. So let us try to understand which is the notification which has been notified under section. So notification 2/2017, which is effective from 19 June 2017, has been notified with reference to section 7, and the following are the officers which are being appointed. So if we see the section 3 and the notification 2/2017, they have appointed the similar kind of officers: principal chief, principal commissioner, all this commissioner of central tax additional, joint commissioner, deputy commissioner, assistant commissioner. Also, they have appointed commissioner of central tax audit or commissioner of central tax audit. So these are the officers which are being appointed by way of notifications. And also they have divided this jurisdiction, this appointment of officers in a various tables with the territorial functioning of that officer. So basically, if we read table 1, it is defining the functions of principal chief commissioner or chief commissioners, under whom the principal commissioner or central tax appeal or additional commissioner or central tax commissioner of audit will be functioning. Then the next table defines the principal commissioner of central tax or the commissioner of central tax, which are defined in table 2 of the notification, and commissioner of central tax appeal and additional commissioner of central tax is defined in table 3, and commissioner of central tax audit is defined in table 4. So basically, we can understand that there are around this principal chief commissioners there are divided into 21 zones in this notification, and each zone is under the supervision of principal chief commissioner or chief commissioner of central zone. And we also have the territorial jurisdiction for principal commissioner and commissioner of central tax, which has notified around 107 commensurate in each 21 zones, and principal commissioner or commissioner of central tax is administrative in charge of this commensurate. Then the third table deals with first appellate authority of central tax, that is the commissioner appeal, additional commissioner of central tax appeal, and joint commissioner of central tax appeal. And it has notified around 49 appellate authority all over India. Then we have commissioner of central tax audit, which has appointed around 48 commissioners of central tax audit for the purpose of GST Act. So this has been notified in 2/2017 notification with the vesting the powers of this administration. Then there is further amendment to this 2/2017, which has empowered the proper officers, which has been specified in table 1 of this notification, and the officers subordinate to them to exercise the powers under 74, 75, and 76, which are the adjudication sections, which has been specified in chapter 5. So specifically, they have given the powers even to the officers who are subordinated to the central excise officer under table 1, specifically for 73, 74, 75, and 76 throughout the territorial jurisdiction of this, as may be assigned by the board. So if you look this 79/2018, that is a specific amendment to which has been brought an amendment to 2/2017. Then we have one more amendment, that is notification 4/19, which also has made a certain amendments by adding the joint commissioner as well as joint commissioner appeal in addition to the additional commissioner. So in this notification 2/2017, they have made an amendment by adding the entry of joint commissioner appeal, as well as wherever there is additional commissioner, they have also added the joint commissioner. So these all are the paragraphs of the reference of 2/2017 notification. So give the equivalent power to the joint commissioner in addition to the additional commissioner under the GST law. Now, section 5 was not a section to be discussed as per this, but without section reading the 5, we cannot completely understand section 3 and section 4 of the GST Act. So that's the reason some part of the section 5 has been brought into this discussion. And before understanding this section 5, we have to read what is the power of officers. So appointment is given in 3 and 4, and 5 is talking on power of officers under the GST Act. So the section begins with, subject to such conditions and limitations as the board may impose, an officer of central tax may exercise the powers and discharge the duties conferred or imposed on him under this Act. An officer of central tax may exercise the powers and discharge the duties conferred or imposed under this Act on any other officer of central tax who is subordinate to him. So before looking into 5.2, let us first read this 5.1 and try to compare it with the Section 3 of a GST Act. So basically, we understood that the notification 2/17 is defining the class of persons who are being appointed. Later on with this corrigendum, they had made an amendment from CBEC. Earlier, if you see the notification, it was saying as CBEC. If you see here, they have used the word CBEC for hereby appoints. And if you see the further amendment also, it also says the board hereby makes the following amendment. And if you see further, they also referred this CBIC. So the CBIC was referred as and for appointing the officers, whereas Section 3 says the government may by notification. So later on, they made an amendment by issuing a corrigendum in July 2019, wherein the word CBC was changed for the words central government. So the government realized that there is a mistake in the issue of notification. So accordingly, they have amended from CBC to the central government. Now let us understand what is the implication of this amendment. So basically, if we see this notification 2/17, that is issued under Section 3 read with Section 5 of this GST Act. Whereas if you see this 5.1, which states that board may impose such conditions and limitation on discharge of functions by the officers of central tax. If you read this 5.1, it says subject to such condition and limitation as the board may impose, an officer of central tax may exercise the power and discharge the duties conferred or imposed on him under this Act. So basically, in simple words, we understand that creation of officers can be done by the central government, but what work to be executed will be determined by 5.1 of this GST Act. That is what work can be or cannot be done is determined by the board under 5.1 because the limitations and conditions are specified under 5 subsection 1 of the GST Act. The power to determine what work can be carried out or not carried out is subject to statutory limitations set by an act is within the board, which has been discussed. Now, for example, if we read 5.4, it specifically determines what is the limitation of the appellate authority. So they are not supposed to discharge the functions of any other central excise officers. So this is also one of the examples to understand what is the limitation which has been set by an act is within the board. So now the next very important aspect to be discussed from this notification is commissioner or additional commissioner of central tax is appointed. If we read here in notification, they have appointed Commissioner of Central Tax Audit and Commissioner of Central Tax Appeal in notification 2/17. But if you read in Section 3, they have only defined Assistant Commissioner of Central Tax and any other class of officers as it may deem fit. So it is not including any officer as Commissioner of Central Tax Audit or Commissioner of Central Tax or Additional Commissioner of Central Tax. So these officers are not is there in Section 3, but it is there in the notification. So is it valid? Is the appointment is valid within the law? So what we understand is whether the said class of officers is fine in 2/17, but it is not there in 3. Whether the central government has the power to appoint such class, which is not mentioned in the Act. So I think we understand from this that it is not there in the Section 3, but it is there in notification. So whether it is valid, according to my view, yes, it derives the power from Section 3.1 because there is a residual clause in Section 3.1 which says any other class of officers as it may deem fit. So I think this is giving the power to the central government to appoint even the Central Tax Appeal, even the Commissioner of Audit and any other officers as it may deem fit. Now the second question is, can this class of officers be created by the board? So the question is, we understand that after this amendment, we are very clear that it cannot be created by the board. The class of officers has to be created by the government. So basically, board cannot create any class of officers. The class of officers are created and notified only by central government. So the board can only state what the officers can do or cannot do under 5.1, which we have already discussed. Now, the very important aspect in this notification 2/17, which states that class of officers up to assistant commissioner. And if you read in that notification, it also states the central tax officers subordinated to them as central tax officers and vest with them all the powers under both the said acts and the rules made thereunder with respect to the jurisdiction specified in the tables. So what do you mean with this? Who are the officers who can be subordinated to the central tax officer? So whether the central government has to create these officers like superintendent or inspector, like how they have created for commissioner appeal or audit, or is there any other way where section 4 can pitch into stating that yes, board can appoint such officers, or is there whether the provision of section 3 will assist? I think I request the mentors to discuss on this, whether 3 is suffice, whether provision to 3 will suffice, or 4 has to be entered to officer below the assistant commissioner of central tax. So I think this issue I've kept as open, but as per my view, superintendent and inspectors are the class of officers. Actually, they have to be notified by the central government. How they have notified this commissioner appeal and commissioner audit, they also have to notify this superintendent and inspectors. But as till date, I have not seen any notification where they have notified the superintendents and inspectors. But however, there is a provision which has been inserted in section 3, which states that officers appointed under Central Excise Act shall be deemed to be the officers appointed under the provision of this act. I think this will rescue to the appointment of this, and they are the deemed officers under this GST law. So accordingly, they can continue to exercise their power as a superintendent or inspector, as the case may be. But I personally believe that they have to notify notification under 3 with respect to 5 to define the appointment of superintendent and inspectors. Then as we all know, how they have defined principal chief commissioner, which is provided by central government. So similarly for superintendent and inspectors also should be appointed. Now the second issue, while reading this notification 2/17, can the central government when the central government has the power to appoint the officers, whether they also have the power to notify their jurisdiction, like whether they can assign the functions to this officer. So let us try to read again with this 3 with reference to 5(1). See, basically 3 is providing the power to appoint the class of officers. One line of thought is that central government has the power only to create this class of officers. So they cannot determine what the board can do, because there is an exclusive power which is given under section 5(1) of the GST Act. And one more argument or one more thought which we can think is, once the central government is given the power to appoint the officer, then I think even they should be given the power to determine the jurisdiction of that officer also. But I think because there is a specific section 5 subsection 1, which has defined what the powers of the officers. So I think board has already notified who is the jurisdiction. So accordingly, I think 2/17 is amended to central government. But what might be the reason? The government, I think when they have introduced this notification, they would have definitely looked into while enforcing the provision. So when 5(1) is enforcing the provision by board, then even 3(1) should also be enforced by the board. I think that was the reason they originally brought into this 2/17. But anyway, after this Ravi Agarwal case and after that amendment in 2019, they have made an amendment from CBC to the central government. So I think that holds good to the 2/17, but this is only a thought process which we can get when we are reading this 2/17 with reference to 5 subsection 1 of the GST Act. Then there is a further amendment of this notification. There is further introduction of notification of 14/2017, which is from 1st July 2017, where even here also the CBC has appointed. So further it got amended to central government, where they can appoint this DGGSTI and DG Director General of Goods and Service Tax and Director General of Audit. So they can appoint these officers. And they have given who are the officers. They can exercise the powers which are there with the existing officers. So they have defined who are the officers. Like if they are appointing Principal Director General or Goods and Service Tax Intelligence, they can derive the powers of Principal Chief Commissioners. Director General Audit, they can derive the powers of Chief Commissioners. So these are the powers which has been defined under notification 4/17 by appointing these officers. And there is a further amendment in 1/2023, where they have even added this Additional Assistant Director, Goods and Service Tax Intelligence, or Goods and Service Tax Additional Assistant Director as Superintendent. So they also have said they have the equivalent function Superintendent. So the appointment has been made of this officers by notification 14/2023. 2017. So as already have said, it has been further amended from CBEC, that is CBIC, to central government by issuing a corrigendum in 2019. Now, there is further section 291, which has defined the proper officers. So here, these are the officers who are being assigned the powers under this for the registration and composition dealer. So if he is an assistant or deputy commissioner or assistant or deputy director of central tax, then they have been given certain functioning under the respect to registration and composition. So there are certain rules which are specifically rules and sections which are specifically assigned to this specific officer under the specific rule and section. So I think superintendent has governed with these rules. So he can enforce these rules and sections. And the function of this assistant has been defined under this respective with relation to registration and composition. So there is a designation of the officer, that is, these are the designation of the officer, and these are the functioning of these officers. Functioning of this section, functioning of the officer under the respective sections and rules. So this has been notified through circular 1/2017. Then we also have a very important circular. I think whenever we look into the notice, any notice, we try to test the limitation. Also, we try to test the jurisdiction. So this circular will assist us to understand whether he is a proper officer under the respective section or not. For example, we read in 67, where it states that the authorization should be made not below the joint commissioner or not below the joint commissioner. So it means the power has been given to the joint commissioner or the officer above the joint commissioner. So the function is the power is arised from that section itself. So for example, if INS 1 is issued by say assistant commissioner who is authorizing the other officer to inspect, then I think the whole proceedings will be invalid because it is not given by a proper officer. So when the section specifies a proper officer and the functioning has been assigned by this section and circular, then it is empowered to enforce that section with respect to the power as assigned to that proper officer. So if we read here with respect to this 3 and section 5 subsection 2, the board has assigned the officers the function as the proper officer in relation to various sections of this central. So I think this circular will definitely help us to understand before looking into any function of this proper officer. So basically, like for example, for principal commissioner, they have defined they can look into the search seizure case or into this 78, that is a transfer property. Then this additional joint commissioner of central tax. So all the 67 inspection, 71 access to business premises. So all this 129. So this is for this e-auction. So I think lot under for goods in movement. So I think there are various sections which has been notified or rules which are notified under the respective jurisdiction of the officer. So I think this will assist us to understand whether the proper officer has that power to issue the notice or to adjudicate that section or the rules as the case may be. So this is the 3/2017 circular which has been issued by the board with reference to 5 subsection 2 of this GST Act. Now this, after reading this circular where they have defined superintendent inspector also, now there is one more amendment which they have made it to this circular, that is 31/5/2018, where earlier the 74 section, what we are reading, that adjudication section, which was under the function of deputy or assistant commissioner. Now it has been changed to even the superintendent of central tax also has the power. So earlier it was only for 73. Now they brought it for, so earlier it was under 73. So now they introduced even 74 also with the under the designation of superintendent of central tax. So that is what the amendment they have made it. So functions relating to section 74 has been brought from deputy or assistant to the superintendent of central tax wide circular 3/3/2017. So this circular is quite important circular, which is giving a lot of important aspect from the perspective section 73 and 74 also. And it also provided this monetary limit for functioning of this proper officer. Like if it is superintendent, I think the limit is 10 lakh. Then if it is a DC, it is from 10 lakhs to 1 crore. And above that commissioner, additional commissioner, it is coming about 1 crore or 2 crore, depending upon whether it is under CGST Act or IGST Act or CGST and IGST Act. So the monetary limits are specified in this circular to enforce that 73 and 74 under the GST Act. So I think this is what the circular is talking with an amendment to 3/3/17. Then we have anything to be discussed till now, or shall I proceed?
You can complete it first.
Yes,
Then
yes. Yes. Then there is a further amendment to this notification 2/17, which has been brought by notification 2/2022. In fact, when I was trying to read this notification, I blindly believed that this has come in 2022 and this has been issued by central government. So anyway, that amendment is made from CBC to the central government, and that is well within the power. But further reading of this notification has gave some thought process, which we'll discuss in the next slide. But before that, let us understand what this notification is trying to explain us. So basically, it is trying to add a further in this notification where it is stating that notwithstanding anything contained in paragraph 3 of this notification 2/17, the additional commissioners or the joint commissioners of central tax, as the case may be, subordinate to the principal commissioner of central tax or the commissioner of central tax, is vested with the power as specified in the corresponding entry in column 3 of this said table. So they have given the power to this principal commissioner, additional commissioner, as well as joint commissioner, and they have notified this 10 commissionerate to pass an order or decision in respect of notice which are issued by the officers by DGGI under section 67, 73, 74, 76, 122, 125, 127, 129, and 130 of the GST Act. So I would like to take the view of mentors and other members. How can the order be passed against 67? Because I believe 67 is only an inspection which we are trying to, is it that order he's referring? Because 67 will lead into 74 and 74 will lead into an order. So why the 67 is referred, that is a one aspect. And already they have specific power for 73 and 74. So why again they have brought under this section to issue an order? I think this has to be understood in detail. And 76, as we all know, it is amount which is collected and not deposited. 122 is penalty, 125 general penalty, 127 is also general power of penalty, 129 for movement of goods, 130 is confiscation. I think these are the sections which has been notified to pass an order in respect to a show cause notice which is issued by DGGI. So I think these are the 10 officers which has been notified under this 2/2022. Now let us understand the validity of this notification. So before that, let us read this circular also, which has been issued based on the notification 2/2022, which has stated that additional commissioner of joint central tax or joint commissioner or some of the specified central tax commissionerate with all India jurisdiction for the purpose of adjudication of the show cause notice issued by the officers of DGGI. So basically, the central tax officer shall issue only the power to issue show cause notice. Adjudication will be made by this notified officers. And basically, I was just trying to read the circular. It also states, irrespective of the amount involved in the show cause notice. So there is no monetary limit which has been specified in this specific case as such. But if we read the circular 38, it has given a power of 5 crores if it is exceeding beyond the state, and if it is a multiple state jurisdiction, then I think they have stated wherever there are the high stakes, that officer should, that coming state should adjudicate the note, that's respective notice. But I think after that, this circular has given a specific power irrespective of the amount involved in the show cause notice. So I think this also look into what is the implication of this adjudication, which has been specified in the circular 169, irrespective of the amount involved in the notice. Whereas 38, if you read the circular, 31, if you read the circular, they are providing the monetary limit for functions of proper officer for section 73 and 74. So I think this is one aspect which we have to look into this. Or might be it is a special power which has been given to these officers irrespective of the monetary limit. So this can be looked as an exceptional power given to the officer for adjudication. Now, understanding this section 3, section 5 of the GST Act, where section 3, in case of section 3, the central government has the power to appoint the class of officers, whereas in section 5, the board has the power to decide the limitation and conditions for the assignment to the proper officer. Now the issue is, in section, in notification 14, what we read, the power to appoint DGGI has been exercised in notification 14/17. Now the power to exercise by them also has been specified by the central government in the said notification, that is 2/2000. Then later on they changed it to central government in 14/17. Now, if we are reading this 2/22, this is specifically contrary to 5.1. If you read 2/22, it is not only talking on the appointment of the officers, it is also talking on the conditions and limitations. I think the power to adjudicate has also been discussed in notification 2/2022. So basically reading that, what the contrary is looked like, this is specifically contrary to 5.1 because power to be exercised specifically refers to conditions and limitation of what officer and can do or cannot do, which power can be exercised only by the board due to the specific wording, which we have already read this. But after reading this 2/22 does not appoint only class of officers, which was the power of CG. If you read section 3, it is only giving a specific power to appoint the officers. But if you read this notification, which states that 10 officers have the power to pass the order, which are issued by GSTI under the respective section. So again, it is saying what they are supposed to do under that respective section, what they are not supposed to do under that section. So I think this is overriding section 3, which is referring in section, because though the notification says section 3 with reference to section 5, but it has been notified by central government and not by the board. So it is a mixture of both section 3 and section 5 of this GST Act. So the aforesaid notification is not at all a notification appointing class of officers. It is just deciding what the adjudication should be done by the officer under the respective section. So basically such power is given by the board, as already I've discussed. So I think central government is just using that power without having any right to give the power of the board, taking the power of the board and issuing this notification. So I think basically what we can understand is this: whoever the 10 officers who are notified are not the either the section has to be it has to be changed with section 5.1 and not with reference to 3, because it is not at all falling into the purview of 3. It is falling under the purview of 5.1. So accordingly, it should be made as board and not as a central government. I think that is what the reading, that was the reading which gave us while reading this notification. So basically, the 10 officers listed are the proper officers, which we have tried to understand. And proper officer as per 291, if you read the definition of proper officer also, they are the officers who are assigned the functions by the commissioner in board. So whether this central government has assigned this function, that is also not happening in this notification. So the central government has, without having exercised the right exercising the power statutory given to the board with reference to the jurisdictional or adjudication. So I think in this notification, the central government does not have the power to state the same under 3. If you read circular 3/3/17, very specifically, it has used the word CBEC. But if you read notification 2/2022, it has used the word as exercised by central government under 2/2022. I think both are contradicting to each other. So I think this might lead into a illegality in that notification. This is one of the thought process. I think mentors can add their view in their discussion. Then we have to try to understand whether this central government, what we are talking, whether this commissioner has got the power from 168. Is it something commissioner in board, whether the power has been derived? So let us understand what is stated in 168. So the first para deals with the this issue, instruction or direction, that I'll ignore as of now. The most important is 168(2), which has specified a special power to a commissioner in board under a respective section. So the commissioner in board is appointed by the board to assign this specific functions under the respective section. So like 2 subsection 91 or 5 subsection 3. So there are certain sections which has been notified under 168. He shall be a commissioner or joint secretary. So to enforce this section, he shall be a commissioner or joint secretary, which is posted in the board, and he will exercise whatever the power which has been given by the board. So as we read 5.1, so similarly, there's a specific section of 168 subsection 2, which has incorporated the commissioner in board actually. Sorry, commissioner in board, as we read the definition, it is nothing but the officer who is there under 168. And one more thought process actually when I was getting when I was reading this, why this commissioner in board is not taken in section 3? Is it something, or is there specific section of 168? That's why we are not required to be brought under section 3. That was one more thought which I was getting when I was reading this 168. So this is a one more thought process. I think we have to look into that because specifically they have defined who is commissioner. They have defined commissioner in board, but whether this commissioner in board is appointed by the board, but he should be appointed by the government, but the powers shall be exercised with the approval of the board. Something that can also be looked into, or is there any specific way to understand why it has not brought under 3 and why it is brought only under 168(2). So this is one more thought process which we have to look into that. And I was just trying to again compare this notification and trying to read what it is stating. What is this proper officer we are trying to read is proper officer in relation to any function to be performed under this act means is the commissioner or the officer of any central tax who is assigned that function by the commissioner in the board. So there is one more specific reference of the functions which can be assigned by the commissioner in the board. So I think based on this, section 168 is operative. Now the commissioner in board has used the power under 168 to state what shall be the proper officer for various sections. The board has the power to state what the class of officers appointed by the central government can do or cannot do. So the power is available by the board under 168 to be exercised by the commissioner in board. So again here the commissioner has again in this notification 2/2022 where the central government has decided the adjudication and by stating that they shall be an adjudicating authority. So here also at least they would have referred 168 by giving a specific power in a specific section that also has not been referred in 2/2022. So only the commission board has the power to assign the function. So that also has not been made in 2/2022. So I think that is one comparison where we can make it with reference to 2/22. One is with 5 subsection 1 and the other one is 168 subsection 2 of this GST Act. So basically 168 subsection 2 states that who shall be the commissioner in the board. So it states that said person have to be posted in the board and such person shall exercise the power after approval of the board. So basically I think if we read 2/17, 14/17 and 2/22, which is providing for adjudication, I think it is not going at par with 2/17 and 14/17, which has been amended from the board to the central government, but it is not in par with this 2/22 because it not even has any board. It has been notified by the central government and not by the commissioning board or nor even by the board under 5 of this GST Act. I think whether this exercise is illegal or is there any other school of thoughts, I just keep this question open for the mentors to see, can we look this 2/22 with reference to 5(1) of this GST Act or with reference to 168 subsection 2 of this GST Act. So this is one of the thought process which we can look because the notification is very important for us to understand in par with 2/17 and 14/17. And in one of the case, actually in Ravi Agarwal case in Chhattisgarh, I think here also they have challenged on this circular which has been issued by the board and the notification which was issued by the board in the initial year, and later on it got changed to central government, but this was challenged in 2019 prior to this amendment, and this amendment was made in 29 July 2019, and they have issued a notification by changing from board to the government, and this has been brought to the government. This has been brought to the court, and accordingly, the matter has accordingly as it is amended. So there is nothing further which has been the petition which is filed has been dismissed, and accordingly there is nothing which hold goods because already they had made an amendment. So the challenge which was made under this as a writ to the High Court has been does not hold any authority or validity because already the amendment was made in by way of corrigendum notification. So this was challenged on the powers of officers with 3/3/17, which is by the board, and the notification was issued by also the board, which would have been the government. But anyway, that amendment was made. So this case does not hold any good, but this was challenged. This is what the point we want to bring out through this Ravi Agarwal case. Then the next very important is appointment of officers. Here also there are some thought process which I was trying to understand is, see, basically it is stating as appointment of officers. So the board may, in addition to the officers as may be notified by the government under 3. So who can be the officers who can be notified under section 3? Because under section 3, we also have a residual clause as any other class of officer as it may deem fit. So I think this also we have to look into who can be the officers who can be, is it only the field officers or is it only the administrative officers? I think that is what we have to look, but it will be majorly an internal document for them to appoint such officers. So they basically appoint, so the board has been given the power to appoint such person as it may think fit to be the officers under this act. And also it states that without prejudice to the provision of subsection 1, the board may by order authorize any officer referred in clause A to H of section 3 to appoint officers of central tax below the rank of assistant commissioner of central tax. So they have the power to issue an order to the respective officers to appoint their officers below the rank of assistant commissioner for proper administration of this act. So this appointment of officers, I think, is a specific power given to a board to appoint a field officer in addition to a executing officers which are there in section 3. So the board has power to appoint such field officers or the administrative officers. Now, basically, I think this is what the section is stating. So basically, this question is anyway open. We'll just discuss at the later point of time. And also, I was trying to read this Karnataka GST Act, a basic of this section 3, how it is notified, and section 4. So the basically it is a replica of GST, but here they have appointed as the following class of officers, which begins with Commissioner of State Tax, Additional Commissioner, Joint Commissioner, Deputy Commissioner, Assistant Commissioner, or any other class of officer. And whoever are the officers of VAT Act will be the officer of GST Act. So I think these are the notifications. So there is a specific notification which has been issued by Karnataka government to appoint the class of officers under section 3, read with 5. So Commissioner of Commercial Tax, Additional Commissioner, Joint Commissioner, Deputy Commissioner, Assistant Commissioner, CTO. So every state would have been issued a notification to appoint the class of officers. And the second difference is in CGST Act, we had this appointment of officers by the board, but in SGST Act, that is in Karnataka GST Act or any other SGST Act, it has stated the government has the power in addition to the officers as may be notified to appoint such persons. So even this administrative officers are also, these field officers are also to be appointed by the government. That is what the difference between what we read in CGST Act and the SGST Act. And the commissioner will have the jurisdiction over the whole of the state or other officers shall subject to. I think a lot of JDN's internal instructions are passed by the respective respective commissioners to direct who will be the enforcement officers, who are the LBO audit officers. So I think this is having jurisdiction over the whole of the state or over such local areas as the commissioner may by order specify. And it also here also, if you see the difference in CGST and SGST, here also instead of board, they have used the commissioner, whereas in section 4, they have used the government. So there is a change in the section. So the power has given to the commissioner will impose an officer of the state tax to exercise the power and discharge the duty. So here the commissioners are issuing all these instructions, powers, and the sections under which they are supposed to, the powers has been assigned under section 5 of this KGST Act. So I think this is what, otherwise it is all replica of the section 5 of this CGST Act. So this is what the notification I have. I have few JDNs, but that are written in Kannada, so I have not added here. So that is also been issued by the respective commissioner. Then this is also one of the decisions, that is Margita Traders, where they have tried to discuss this reference of section 5, subsection 3 and section. So I think let us try to understand this 5.3 and then I'll just go through this. See, the 5.1 we have read as of now, and 5.2 we have seen that this circular 1/17 and 3/3/17 have been issued under 5.2 of this CGST Act, where it states an officer of central tax may exercise the power and discharge the duties conferred or imposed under this act on any other officer of central tax who is subordinate to him. But if we read section 5.3, which specifically states that the commissioner may, subject to such conditions and limitations as may be specified in this behalf by him, delegate his powers to any other officer who is subordinate to him. So is this requires any specific notification, or is this require any specific circular or authorization? So the decision of Margita is saying this doesn't require any notification. This is the inbuilt power which has been brought under by subsection 3 of this GST Act, and accordingly they have just tried to bring out here that issue is, the issue here is the commissioner has given this delegated the functions to a deputy commissioner, and Deputy Commissioner has issued the notice under 74, and the issue of notice by the Deputy Commissioner was challenged under this GST law. So the issue is whether the assignment made is conforming to the jurisdiction on the Deputy Commissioner. So whether the Deputy Commissioner is a proper officer he is a proper officer, but whether he is assigned under 5.3 by the Commissioner. So basically, issue of jurisdiction in adjudication by DCCT, basically the court observed that 5.3 is only the source of power to subdelegate the functions vested in the Commissioner to be exercised in favor of any officer subordinate to him. So I think it is only, there is no requirement, only the instruction given by the Commissioner or any administrative order passed by the Commissioner will suffice to subdelegate its own function to the subordinate officer. So here it doesn't require any specific notification or any specific circular, but this issue has been challenged in this case. And the decision, when I was reading this decision, it states that neither there exists any procedure or stipulated prescribed by the law with respect to the mode or manner in which the power to subdelegate may be exercised, nor the Commissioner was required to obtain any approval of the state government in that regard, nor there exists any requirement in the law prescribing issuance of notification. So there is nothing which has been specified under the CGST law nor under SGST law to say that to exercise the power under 5.3, there should be notifications or there should be any amendment in the law, or there should be any power, any approval which has to be obtained from the government. So I think it is an independent power which has been given to the Commissioner to subdelegate to its subordinate officer. So accordingly, it has been held that the officers which are appointed under 2/91 is valid, and the orders which are issued by the commissioners, that is administrative officer order, which is issued by the Commissioner, is within the power exercised under 5.3 of the Act. So accordingly, it is valid, and accordingly, the petition was dismissed. So I think basically this decision will say that notification is not required for 5.3. Only the administrative order will suffice for enforcing that power, enforcing the functioning of that power under 5.3 of this GST Act. So this is one of the decision. And then we have Amazonite steel. It is not very specific. Basically, here it deals with the provisional attachment under 83, which was issued by Principal Commissioner of Central Tax, who is higher than the Commissioner of Central Tax. So it is well within the power. And accordingly, it is well within the power of 5.2 of this CST Act, as they possess the power to pass the provisional attachment. I think when we read this provisional, it says if the Commissioner believes that there is a interest. So the word Commissioner, it need not be read so strictly. Even the officer above the Commissioner can also be the proper officer to enforce Section 83 of this GST Act. Then today morning, actually yesterday, while I was having discussion with Arpit sir, we were trying to understand, is there any difference between the assignment of power and delegation of power? So I think one of the decision which I was trying to get is in one of the Asho Industry case, where they have very beautifully discussed what do you mean by assignment of power and delegation of power. So delegation of power is strictly discussed in 167 of this GST Act, which says that if you have to delegate the power, then it has to be issued by way of issue of notification, and it is subject to certain conditions. Whereas this assignment of power is given under 5 subsection 2 of this GST Act. So I think we have to understand there is a difference between the assignment of power and delegation of power. So basically, if you read in 5.2, it is power of the board to assign officers to perform the functions as proper officers in relation to various sections of this GST Act. I think here in this case, the petitioner has misled. They have misled this 5.2 as 167 and hold that there is no notification which is passed. So accordingly, it is invalid. So I think even this was also challenged, and it has stated that it is well within the power of 5 subsection 2 of the GST Act and not 167 of the GST Act. So I think these are the certain references I was just trying to get when we were trying to read this section 3 and section 4, and some reference of 5 was required to completely understand this 3 and 4. And that's the reason I've just brought some reference of 5. I think this is what I wanted to share on this topic. Is there anything, Arpit sir, will you take it?
Ma'am, you have gone into such a detail. So for the benefit of all the members who are present here, what's your final view on the jurisdiction and the competence of DGGI in terms of issuance of notice and passing of the orders? that whether they can issue the notice as well as pass the orders, or whether they can only issue the notice and the order has to be passed by the jurisdictional officer.
I believe the order should be passed by the jurisdictional officer, sir. The same, officer who is audit officer and the adjudication officer should be different officers. They both are different proper officers. They cannot be the same officers. But
So,
yes, sir.
so in terms of notification number 2/2022, where you have referred that those 10 officers have been given the power to.
Yeah, that is what I was just trying to say. Is it an exceptional notification in a specific case? We have to refer this. That is what the question arose when I was reading. And specifically here they have given the power only to the additional commissioner or joint commissioner under this commissioner to adjudicate the notice which are issued by the officers. So these officers are, the DGGI is only going to issue the show cause notice, and this commissionerate or this additional commissioner or joint commissioner has to pass the order under the respective section. But only thing what I was just trying to understand, sir, how they can pass the order under 67. I think that is what the thought process which gave us, because 73, okay, they can issue the show cause notice, 74, 76 is fine. But 67, I don't know, I couldn't take it up, or is it a specific search or seizure case, or what reference is to be brought here that has not been brought in any of the circulars?
No, so the issue is that they have mentioned 10 officers. So for only those 10 DGGI jurisdictions, whether they are competent, and rest of the notices which have been issued by other DGGI offices, they have to be assessed by the respective jurisdictional officers. What is the exact scope now as per your understanding?
Sir, basically, if you read this notification, it is giving the power from 3 and 5. So if we read this 3 and 5 section, and specifically they brought this para. So I think this notification is an independent notification with the other circulars and notification, what I understand, because this will apply only in a specific case and not in the case of a regular proceedings. So that is what, because the power, they have not used any officer below this commissioner or additional commissioner. So I think reading of that, I understand that it is a specific case in a specific scenario where the notices are issued by the DGGI. In this scenario, only these 10 officers are being the proper officer to adjudicate those cases.
Okay.
I think I've understood your question, sir.
Yes,
I think Annapurna madam, you are right. I think 169 gives a clarity now that with regard to this, when there is a DGGI has issued a show cause notice, it has to be adjudicated by the additional or the joint commissioners of that particular jurisdiction actually.
Yes.
So they will reallocate that. Yeah.
Yes. With all India jurisdiction. Yes. Any other thoughts?
Annapurna madam, I have one doubt now with regard to our Karnataka jurisdiction. So can we, with regard to the Karnataka jurisdiction, hello?
Yes, sir.
Yes. When there's a Karnataka jurisdiction, see the adjudication and the show cause notice, that is the audit as well as the show cause as well as the adjudication is done by the same officer.
Yes.
Is there any in the state, this is the process which is being followed, but I could not see any specific notification to bring this particular thing similar to this 169 which is available. So any views on that from your end?
Yeah, actually, as you rightly said, the same officer is doing the audit and adjudication. But there is some JDN which has been issued by the commissioner to those proper officer actually. So I was just referring that JDN yesterday, which internal instruction has been given by the commissioner under 5 of this KGST Act, and accordingly they are under that JDN, they are enforcing that section actually.
Okay, okay, thank
No
you.
such specific notification which I was able to trace out in this.
And I did not look at
Instruction, yeah, only that internal instruction which was giving a thought to say that the same officer can adjudicate under this.
Okay.
65 and 70.
But recently when we just met the commissioner, we raised this issue actually.
Yes.
So they were of the view that this particular point they have mentioned that I think if required, the assessee can call for change in the jurisdictional officer wherever they feel that there is, they feel that it is not being done, due justice is not being given.
Okay. So, but no specific instruction which I've seen.
There is no specific
brought after
instruction,
that?
but it seems I heard that a couple of cases in Bangalore, they have
They have
changed the
applied.
jurisdiction. Yeah, they have applied and it has
Okay.
been reallocated to a different officer.
Okay, once you apply, then they reallocate. Otherwise, on their own,
Yes.
they're not doing, right?
May I ask one question, please?
Yes, sir.
Madam, in case I have got a case where DGI issued a show cause notice. No, it is pending for adjudication before additional commissioner or joint commissioner. Okay.
Yes, sir.
During the proceedings of DGGI, the joint commissioner no posted here was the deputy director there in DGGI.
Hmm.
No, I think he has made the case, he initiated the case, and then no, he will be there to adjudicate it. So for this change of jurisdiction, whom should we apply? To the commissioner or to the board? Where?
I think if it is, I think it should be made to the commissioner itself, because you can make an application, as Chandrasekhar was pointing out, for the change in the jurisdiction. I think that can be brought out with this reason, stating that he is the same officer who has been the officer who has issued the show cause notice. So accordingly, I think they will consider it.
Madam, under what section we can apply specifically? We have to quote some section to say them that he is empowered to do it. Under what section, madam?
I think Chandrasekhar, any section commissioner has specified on that day, or only as a general they have specified for a change in the allocation of officer?
He did not mention any specific notification, but they told that once on the request, but this is from the state government. What sir is mentioning?
Yeah, it's from the central government. I got it, but I want to
Central
understand.
government, I also did not get that point, madam, actually.
Okay.
Arpit sir, can you rescue us actually when I apply to the commissioner? So I have to quote some section under which section he has got the power.
Sir, in my opinion, the basic principle of law is that one who makes out the case cannot pass the order.
Good, that is good, sir.
Yes, sir.
And in that case, you can make the challenge before the officer himself that since you were the part of the process wherein the case was made out, so you are not competent to hear the case. And once the objection has been raised, and even if then he passes the order, then you can take that preliminary objection in the appeal itself.
So that is the sir, that is a case where we will confront upon this point. But
Yes.
if we want to buy a piece, and yes, we just wish to approach the commissioner or somebody who you may like or who is empowered, then sir, actually we would like to take that route. That this does not happen in the first stage.
There is no specific provision in law which
Yes.
provides you can raise the jurisdiction issue before the commissioner.
Correct.
In my opinion, it has to be first raised as a preliminary objection. In our case, also one in Rajasthan, there was one notification wherein they had vested the power with the person who had made out the case. We made a objection in our first representation before the officer, and subsequently they have amended the notification itself and brought out the chain. So in my opinion, there is no specific provision where you can challenge before the commissioner. It's better that you raise the ground before the officer himself and let him decide. And if he even then he moves forward, then you can make it part of your appellate proceedings as a preliminary.
Thank you, Arpit sir. Thank you, madam. Thank you.
I
Thank you,
would
sir.
like to add here, Arpit ji.
Yes, sir.
In Rajasthan, what has happened that this enforcement wing has made out some searches in one of the cases, and then they issued show cause notice, and then they have done the adjudication also. They have passed the order. So we have challenged that before the authorities as well, but the authorities have passed the order, and then we have moved to High Court and challenged this particular action, that the person who has done that investigation cannot be the adjudicator. So this we have taken the ground and our appeal has been admitted by the High Court. So far as
And for the benefit of members, as far as I can remember, I will also share that there is one Allahabad High Court judgment in 2018 or 2019, wherein the writ has been admitted and decision has been granted in favor of the petitioner by holding that the person who makes out the case cannot decide the matter.
So that will, sir, very nice. Kindly share in the group that case, sir. Huh? Then
Yes.
I will quote that case, sir. While approaching the additional commissioner, I will cite that case. Thank you.
Sir, I have one question to ask. Hello?
Yes.
Yeah.
Yes.
Yeah. So now what happens in a scenario where, let's suppose intelligence wing, there's one commercial tax officer who has made out the case, but the show cause notice is issued by another commercial tax officer under the same intelligence wing. So now can we hold out that the person who has made the case cannot adjudicate, because now the person issuing the show cause notice is a different officer, but coming under the same intelligence wing?
So authorization was given to which officer for conducting?
Yes, sir. Authorization was given to CTO 1, let's suppose.
And the notice has been issued by another officer.
Yeah, notice is issued by CTO 2.
How can it be done? Because the person who has been granted the authorization to conduct the search can only make the case, or the person who has been who has taken over the charge of the same place. Another person cannot make out the case.
So here in Tamil Nadu, there's a legal and review cells are under intelligence. So the persons who are actually carrying out doing the inspection are different, and the person who's giving a show cause notice is different, and both are coming under the same intelligence.
Provision to transfer of case from the person who carried out the search to the person who is issuing the notice, whether a specific notification being issued has been issued. See,
I'm
prior
not
to
aware.
GST here in Rajasthan also, we had a instruction by the commissioner that the person who has made out the search would only be issuing the notice, and the order would have to be passed by another officer. Similarly, if there is since it is basically a state issue of the TNGST, so is there any specific notification wherein they have said that the person who has carried out the search transfer the case to another officer to for issuance of the notice?
Fine, sir. So in that case, if at all there's one notification, sir, that the person who has made the case, he will issue a show cause notice, and another person will be adjudicating it, and both are under the same control of same joint commissioner. So can we still take the ground of biasness, sir, because it is they're coming under the same joint commissioner?
No. In my opinion, the only thing which the law constitution lays down is the person who has heard the case should pass the order. So in case the investigation has been carried out by one officer and then the case has been transferred to another officer for issuance of the notice, the only mandate is the order has to be passed by another, say, third officer. The only mandate is that the person who is passing the order should have heard the case. So there is specific restriction that the person who has carried out the search is the same who is issuing the notice, if proper enabling notification or circular has been issued for that purpose.
Thank you.
I think what is happening is that the joint commissioner under whose jurisdiction the CTO is working, the CTO is making searches, and the joint commissioner who the boss of that CTO is issues show cause notice, and then he adjudicates the order of the same wing. This is what is happening in state tax.
And the question, Virendraji, was that one person under the joint commissioner had carried out the search, and that another person who is under the same joint commissioner is issuing the notice. It is not that the joint commissioner himself is issuing the notice.
Maybe that is the difference.
Yes.
And what about the audit practices? Whereas in Rajasthan, the audit team who has conducted the audit, they issue the show cause notice and then they pass the order, adjudicate the show cause notice. Whether it is happening in other states also?
Yes, sir.
Yes.
Okay, the state practice is that
Yes.
like that.
Two questions which were raised by Annapurna ji during a deliberation.
But sir, sorry to interrupt.
Yes.
Regarding the issue which we have been the members have been discussing, can you bring it into context that the person, say, who has investigated or who has issued the show cause cannot be the judge? Is it a limitation? I can't see this is a limitation in the GST Act. Is it in the constitution? Is it by judicial practices? And what, sorry, just let me complete, please. It will be a little longer. And another thing is, say, is it specific to Section 67 like activities of searches, etc.? Because in 73, 74, it is regularly the officer who issues the SCN, the same officer adjudicates. And what happens in searches, like one of the members had just said, that search was completed by the search team, and then they prepared their final report and it was forwarded to the adjudication section. And the adjudicating officer prepared a show cause notice based on that, and then followed that by the orders after the hearings, etc.
See, Guriji, the two questions which have been raised by you, that whether whether any such restriction is coming from the statute that the person who makes out the case cannot be the adjudicating officer. It is not coming from the statute, but from the principles. And yes, if the same principle is there, then the same should be applicable on Section 73, 74. In my opinion, the anti-evasion proceeding stands on a different footing because there is a specific activity which is being carried out at the premises, and then the entire case is framed out on the basis of that activity, and then the notices are being issued. So in the pre-GST regime, also for the purpose of these anti-evasion activities, there were specific circulars that in case of anti-evasion, the person who is making out the case cannot be the adjudicating officer. And that principle itself has been followed if we go through the various circulars which have been issued, that the audit wing in CGST specifically, that the audit wing, if it is issuing the show cause notice, the adjudication would be done by the proper officer, because in case of a audit under Section 65 or in case of a search under Section 67, there is a specific activity or an investigation or a, what I can say, go through of the documents by a team, and then only the further action is being proposed. Whereas in case of Section 73, 74, the material is before the officer and he does not conduct any prior inquiry on the basis of material available before him. He issues the show cause notice based upon the relied upon document. This is the broad difference which I can understand, although it is not specifically coming out from the statute. And for the query that the person, a joint commissioner under whom a person carried out the search, and then the another officer under the same joint commissioner, whether he can issue the notice and a third person can decide. In my opinion, the only restriction which is coming out from the statute as per Article 14 is that the person for effective hearing, that a person who hears can only understand what the other person who is aggrieved has to say, and then only he can take into account that thing while passing the order. So this is coming on from the Article 14.
Here the last part of the question, and we may add audit also to the search. Is it necessary that the audit teams issues the show cause notice? Audit may complete their final report and pass it on to the adjudicating authorities. This is the practice which we are talking about, that the SCN is issued by separate authorities and the adjudication is done by, that is being followed by central authorities since earlier law also, and that is how their notifications are structured, but it is not the same manner for most of the states. So is it necessary that the enforcement teams or the audit teams issue the SCN? They may just complete their reports and forward it to the adjudicating authorities. That was being done in VAT regime also. And then under the Section 73 or 74, the relevant sections under GST, the proper officer prepares the notice and proceeds ahead. What do you have to say on that, sir?
Guriji, I totally agree with you, because if we go through Section 65, initially for me, the understanding was also that what you have said, because up to Section 65, from Section 65(1) to Section 65(5), the section uses the term authorized officer. And in Section 65(6), for the purpose of conclusion of audit, the section uses the term proper officer. So there is a two distinct terms which have been used specifically. One is authorized officer, which is nothing but under section 65(1), wherein the commissioner authorizes the officer to carry out the audit, and 65(6) uses the term proper officer. So it has not been yet judicially analyzed that what is the difference between authorized officer up to section 65(5), and from 65(6) why the section has used the proper officer. In my opinion, I second your view that if we go through on a literal interpretation, going deep down, there might be some other view that the audit has to be conducted by the authorized officer, and subsequent proceedings, that is the conclusion of the order, communication of the final audit report and issuance of the notice, that has to be done by the proper officer or the jurisdictional officer.
Sir, this practice was being followed and center exercise regime also. Audit team was never issuing the show cause notices. It was only the proper officer jurisdictional range which were be issuing the notices.
So as and when we will be taking section 65, whoever would be the speaker, we would be asking specifically on this issue also. Now, many questions have been raised by Annapurna ji during her entire preparation, and it was a thought-provoking and enlightening session. And so many other issues that somewhere down the line, even we have lost count that how many nitty-gritties are there in section 3 and 4, which we, in my opinion, there have been no seminar on this issue up till now on any platform that what section 3 and section 4 says. And ma'am, you are not the only one who is studying it for the first time. Many of us, including myself, are studying section 3 and 4 in such detail for the first time, and that was our intent, being of the entire admin group, Unni Krishnan ji, Arup ji, Venugopal ji, and myself, that when we are discussing a section-wise analysis, and we have such great minds amongst us, we would be definitely coming out with something new. And the questions which have been raised regarding the proviso of section 3, where it provides that provided officers appointed under Central Excise Act shall be deemed to be the officers appointed under the provisions of this act. In my opinion, the decision which we have referred, Ma Geeta Traders versus Commissioner of Central Tax, in para 15 of the judgment, it gives the answer of the why the proviso is there. And if I can read through verbatim, and rest all the members can go through that judgment. It says section 4 subsection 1 of the act empowers the state government, this is for UPGST Act, so therefore they have referred state government, to appoint a person as an officer under the act in addition to the class of officers specified under section 3. Since the deputy commissioner is an officer falling under the proviso to section 3 of the act, section 4 subsection 1 has no relevance to present controversy. So in my opinion, since superintendents were already officers under the proviso under the Central Excise Act, so in my opinion, going through this decision only, applying the rationale of this decision, there is no separate requirement for them to be notified as an officer by the central government. But at the same time, if we go through section 3 and section 4, wherein section 3 empowers the central government to appoint following class of officers by notification. Section 4 also authorizes board to appoint officers. If we go through the State GST Act, both section 3 and section 4 only refers to the state government. So there is a unanimity or a commonness amongst the exercise of power under section 3 and 4. But if we go through section 3 and section 4 of CGST Act, they authorize both the board and the government, board under section 4 and the government under section 3, and somewhere down the line there is a contradiction among section 3 and section 4 regarding the power to be exercised, which we have referred that board has exercised, central government has exercised the power of the board, and whether it can be done. Although I do not have a clear answer, but what I have read up till now regarding the sub-delegation, I am referring to GP Singh regarding the sub-delegation, and it says when a sub-delegation as permitted by the Enabling Act is made, it does not divest the authority, making the sub-delegation of authority of a statutory authority. he may cancel the subdelegation and resume his authority, and he may even exercise concurrent powers without cancelling the subdelegation. So whether it is a case of a concurrent power being exercised by the central government or the board, since central government is higher in hierarchy as compared to the board, or whether central government and board are two authorities in GST with a parallel, none of the authority being higher than the other. This is something which has been brought by you for us to ponder upon and think upon and come with a conclusion as if at all it is possible in the next session. And
Sir, actually this 3 and 4, which is there in the SGST Act, and 3 and 4, which is there in the CGST Act, as you rightly pointed out, section 3, which is talking on class of officers, section 4 is given the board. So I think there is some power which has been vested with the board also to appoint the officers below the assistant commissioner. But if you read subsection 1, it says in addition to the officers appointed under 3. So this is giving a contradiction to understand who can be the officers who are not notified under 3. So that is a one thought process. I think we have to look into that, because when there is a residual entry in 3, which says that any other class of officers as it may deem fit, and we are trying to bring out based on proviso that even superintendent and inspectors are included in that any other class of officers, then who can be the officers who can be appointed by the board under 4, because they have used the word in addition to. So that is one thought process I think we have to look, and this has been brought even under this SGST Act also. So that is it something they want to derive that power to appoint any officers other than the officers who are there under section 3, or is there any other aspect to bring out that section 4? So because it says the board may, so it is having an option to, in addition to the officers as may be notified by government under 3. So appoint such person as it may think fit to be the officers under this act. I think this is also one more thought process which we have to try to understand who can be the officers, because we are very rightly understanding superintendent, inspectors, they are brought under 3. Then who can be there under section 4? I think that also we have to look into this. I couldn't find any order, because the section says the board may by order authorize any officer to appoint officers of central tax below the rank of assistant. I think this might be some internal order with the department. But who can be the officers? I think they are giving a power to these officers to appoint the officers below the rank of assistant commissioner. So can we say that the superintendent or inspectors, the power should be given by the board to the respective commissioner or respective officer, and then that respective officer will appoint the officer below the rank of assistant commissioner? That was my point of view on the superintendent or inspector. Because first of all, it is not separately notified in notification 2/2022. Then we are bringing this reference of this decision and that provision saying that the central tax officer or VAT officers are deemed to be the officer under the CGST Act, and accordingly they are the deemed officers, and accordingly they are well within the section 3. Now coming to the section 4, the section 4 is very specific on this approach of appointing the officers below the rank of assistant. Is it something they are issuing an order to the respective commissioner to say that, okay, you can appoint the officer below your jurisdiction? So I think that is what we have to, I also had a thought process when I was reading into that superintendent or inspector under 3 and 4 of this GST Act.
Ma'am, whether any notification or order has been issued up till now under section 4 subsection 2? If
I did not find, sir. I tried to search exactly yesterday and try to see is there anything. I was rather reading any other JDNs, but I couldn't find anything as specific, sir, till now. Where if any of a member find it out, please let us know, because I felt this will be a internal document of the department where the board will issue to the respective officers to appoint the officers below their jurisdiction. So that's the reason I think we may not find this in the public forum, but it should be by order. This is fine. This is one aspect. So can we look at appointment of inspectors or superintendent under 3 in residual clause or proviso or for subsection 2 of this GST Act? This was one aspect I think we can look into that. But as on till date, as there is no order which was there in this in public forum. I understand that even section 3 proviso will hold good till any further amendment is made to that section. Then what is the relevance of this actually? What is the relevance of 4? Actually, that is what I wanted to understand. When section 3 has very specifically notified the officers.
Yes, that is what I was highlighting, that if we go through SGST Act, both for section 3 and section 4, they have referred state government.
Yeah, here they have referred the government again in addition to the officers.
But for section 3 and section 4, the power has been vested with the government only. But if
Yes.
you go to CGST Act, section 3, it refers to central government, and section 4, it
Yes.
refers to the board.
Yes.
So
Sir.
there is concurrence of power with the government and the board for appointment of the officers. The first is whoever has been appointed by the central government, they need not be further appointed by the board. But in addition to whoever has been appointed, if the board deems fit, there is a concurrence of power given to the board also for appointment of officers in addition to who have been notified under section 3. This can be a holistic interpretation of both section 3 and section 4, because no section is overriding the other section.
Yes.
But I'll agree with you, and I'll also like to point out that in this SGST Act, there is no clause I, which is there in section 3 for the CGST Act. And another thing, I will not agree to what ma'am is saying, that section 4 is only for officers below the assistant commissioner of tax. It can be for any other officer. They may create any other grade of officers. Let us say, let's assume between assistant commissioner and deputy commissioner. Section 4 can be used by the board for the CGST Act and by the government for this. So it is not to be read that it is only for the officers below assistant commissioner.
Sir, I think if we read, then I think it will fall under 1 only, no, sir? Because 4.1 specifically states that the board may, in addition to the officers, appoint such person. So if any officer is appointed in between DC and JC, I think that is falling under 4.1 itself.
No, that is just giving the specifying the names which are there. It is not saying they are naming, it is saying namely these officers.
Yeah, appoint such person as it may think fit. And again, it is coming out without prejudice to the board may by order authorize any officer. Yes, sir.
If we read section 3, section
Yes,
3 first says for the CGST Act.
Yes, sir.
The government may appoint namely. So they have
Yes, sir.
named H up to
Yes, sir.
H. And
Yes,
then in clause I, they say any other class of officers. So there can be any class of officers intervening between A to H also.
Okay.
It is not hard coded that there can't be any other clause in between these. We can find that various kinds of commissioners, etc., in different administrations. So that is not that there can't be any other class. So any other class that is there given in the section 3. And I'll agree with what Arpit sir is saying, that the power to the board in subsection 1 of 4 is concurrent with what is the power given to the government in the GST Act. And in state government, in the state governments, there is no separate board. We know that there is no separate board, and we don't have a commissioner in the board. That is the reason also for the differences in section 168. So there was no need of clause I in the SGST Acts.
Okay.
So it becomes a simultaneous power. But in central government, the structure is that the government and there is a board also. In state governments, there is no separate board. So it was decided that the states, they don't require clause I of the section 3. So that is why it has been not added there. And section 4, subsection 1 saying the government is sufficient.
Sir.
Hello.
Yes, Arpit sir.
Yes, sir.
If you allow me to ask a question, though not directly related to section 3 and 4, this is pertaining to section 168, where we see that, few circulars are issued by exercising the powers of section 168. And on other hand, we see few circulars are not being issued in exercise of power 168. In fact, no reference of sections have been mentioned in few of the circulars. So what is the reason behind it?
So, can you give some any examples that which are what are the circulars which have been issued without exercising power under section 168?
Yes, why not? Just a minute.
Just in the intervening period, I would like to, we would take the last question which has been raised. And before that, one specific judgment which came to my knowledge, since we have discussed section 5, subsection 3. It is of Uttarakhand High Court in case of Vinod Kumar versus Commissioner Uttarakhand State GST, wherein they have relied upon the Supreme Court judgment issued given for section 83. In that section 83 judgment by Honorable Apex Court, they have said that in that case, the power to provisionally attach the bank account was delegated by Commissioner to the Joint Commissioner. And the Joint Commissioner exercised the power to delegate the provisionally attach the bank account. So the Honorable Apex Court said that since the delegated power has been issued in exercise, in effect, it is actual exercise of the power by the Commissioner to provisionally attach the bank account. Now, applying the same principle, Uttarakhand High Court in a regular assessment proceedings, proceeding under section 29 for cancellation of registration, they referred section 5 subsection 3 and said that the power to cancel registration has been delegated under section 5 subsection 3, and since they have been delegated under section 5 subsection 3, they are in actual being exercised by the Commissioner himself, and therefore this order would not be treated as an order passed by the adjudicating authority. So this is one decision which members can refer upon, and then in my opinion, section 2 subsection 2 clause 91, which ma'am has also highlighted, there's a difference between an assignment and a delegation. That this decision can be seen in light of the difference between an assignment and a delegation.
Sir, I was waiting to ask whether we will be taking section 5 separately, because this is an important decision Uttarakhand, which was not covered. And just I'll give my brief views because the time is already 10:30. So in section 5, there is subsection 1 and subsection 3. So some of the states have issued their notifications or circulars or orders, whatever the notifications for the powers as proper officers under subsection 3, and a few of them have done under 1. So if it has been done under 3, then this is the challenge which Uttarakhand High Court has done, and that is being challenged. Because that is a very harmful, the effects of this decision are very harmful for the state's admins, the administrations of the state. So my personal view is that all that delegation should have been, the powers should be distributed by subsection 1 of 5. Very few states have issued those notifications using subsection 1. So that is just a brief of it, sir.
Very correct, sir. Very correct. Totally agree with you. Yes, last question regarding the circulars being issued.
Yes. So Arpit sir, if you notice this circular 167 and 168, okay, these circulars, no, this is just an example. You may find number of circulars, being issued without referring to the powers of section 168, like 168, 167 recently issued. Not recently, in fact, 2021 circulars.
This is one issue which I have not come across or have not gone into detail. If any member gone into detail, then they can give their views, or else we take it in session once we can go through that why this anomaly or difference is there in terms of issuance.
Yes. And I will try to make a comparison, which type of circulars, because, in at number of places I try to, compare it, where I found that, in case of issuance of FAQs, okay, I just try to compare it, whether in case of FAQs, they are exercising it or not. I find that in case of FAQs, even, there is an anomaly. Somewhere they are exercising the power, somewhere they are not mentioning the same.
Okay.
Okay.
So we this is for the members and what I can say that the entire session today is for something to be pondered upon by the members in detail. And whatever questions have been raised by Annapurna ji, they are valid questions, and there might be difference of opinion. And in some cases, we have not even thought upon them to be discussed. So handing over the session back to Unni Krishnan ji for his final views and the vote of thanks.
Thank you, Arpit sir. First of all, I would like to thank our learned speaker of the day, Annapurna madam, for enlightening us on the intricacies of section 3, 4, and the various notifications, orders, and the importance we have to assign to assignment, delegation, etc. I'm sure that we will have more discussions on these lines when we take up sections 5 and 6 and the connected issues and the divergence in the way multiple states have sought to exercise these powers. Now, I'm sure that none of us would have attended any session till date in the past 6 years where we had discussed section 3 and 4 in such depth. So I'm sure that all the members appreciate the excellent research that has gone into taking over the session for 1.5 hours, ma'am. So we thank you again for being such a learned speaker and detailed discussions on this, and we request that the PPT may be shared across in the group so that those who missed the session today, while they hear the session on the video recording, can go through the slides and listen to the deliberations that has gone today.
Thank you
Thank
so
you
much.
all members for being such an active audience, and let us keep our Saturday morning sessions, and we'll take up the next session on next Saturday morning. Thank you all.
Thank you all.
Thank you.